Good morning, everyone. Just one last check. Does anybody else need the download for the digital copy? Okay, we'll give you a few more minutes to do that, and then we're going to get started. Okay, good morning, everyone, and welcome to the 9th Annual Estate Planning and Community Property Law Journal, CLE and Expo. My name is Amanda Kraynok, and I am the Editor-in-Chief for Volume 9 of the Estate Planning and Community Property Law Journal. The EPJ is the only student-led publication of its kind in the nation, and its audience includes attorneys, judges, professors, students, and many other estate planning professionals. Our journal publishes outstanding student comments and many other scholarly articles written by national and international experts in the fields of estate planning, community property, and related topics. Accompanying the printed version of our journal, we have an online edition, the Codicil, which can be accessed through our website at epj.us. Today, we are pleased to bring you the largest event of our journal's history. As expected, an event of this magnitude involves significant planning and details, and we are fortunate to have our executive symposium editor, Michael Auten, at the front of it all. Michael has gone above and beyond to expand the services and functions of this year's CLE and Expo, and for that, I thank you. Please welcome to the stage, Michael Auten.
Thank you. Good morning, everyone. Thank you for attending. This event has been a year in the making, and I'm so glad to have you all come out and join us and hear the amazing lineup of speakers that we've brought to you today. I also wanted to say thank you again to all of our sponsors. We had a reception to thank them last night, which was fantastic, and we couldn't do this event without all of them, so thank you very much. Both Happy State Bank and Southwest Bank are taking part in our expo out in the kind of forum area outside the auditorium. They will both be holding raffles after lunch, so please stop by and say hello and get your name in their drawings if you'd like to take part in that. Thank you again for being here, and we'll go ahead and get started so you guys can hear the great lineup we have for you today. Amanda?
Thank you, Michael. We are very excited to have the Interim Dean of Texas Tech University School of Law, Dean Richard Rosen, to provide opening remarks. Dean Rosen received his law degree from the University of Miami and an LLM from the University of Virginia. Professor Rosen joined the faculty at Tech Law after completing a distinguished career as an officer in the Judge Advocate General's Corps, U.S. Army. He was a litigator at a Miami law firm for several years before joining the Army as a judge advocate. Before retiring from the military, Professor Rosen was Commandant of the Judge Advocate General School, U.S. Army in Charlottesville, Virginia, where he commanded the Army's ABA-recognized law school. Please join me in welcoming Dean Richard Rosen.
Good morning. It's my pleasure to welcome you to the Law School and the 9th Annual Estate Planning and Community Property Law Journal, CLE. As you can see from the program, the CLE offers an exciting lineup of speakers, both academics and practitioners from around Texas and across the nation, and includes a wide range of interesting and cutting-edge topics. For those of you who will be in town tomorrow evening, I want to mention that we'll be hosting our 13th annual Law School Gala at the Overton Hotel and Convention Center. In addition to honoring our distinguished alumni, we're fortunate to have as a guest speaker this year Mr. Jeffrey Toobin, who is the senior legal analyst for CNN, staff writer for The New Yorker, and a best-selling author of such books as The Nine, The Oath, Too Close to Call, and most recently, American Heiress, the wild saga of the kidnapping, crimes, and trial of Patty Hearst. If you are interested in attending, we still have tickets available. Just see me or anyone in the administration offices. Finally, I would like to particularly thank the members of the EPJ for their incredible hard work in putting together this CLE. Thank you.
Thank you, Dean Rosen. We have brought an outstanding lineup of speakers for today's events with presentations covering a variety of issues in the fields of estate planning, community property law, as well as related topics such as taxation. So without further ado, let us begin. Our first speaker today is Mr. Craig Hopper. Mr. Hopper is a partner at the Austin law firm Hopper Mikesha. After graduating college from the University of Texas at Austin, Mr. Hopper obtained his JD from Duke University School of Law. Following law school, Mr. Hopper clerked for the Honorable Guy Herman of Travis County Probate Court No. 1 and has worked in probate and estate planning for 17 years. Mr. Hopper is a board certified in estate planning and probate law, a current member of the probate and estate planning section of the Austin Bar Association, as well as a member of the former council member of the State Bar of Texas Real Estate, Probate, and Trust Law section. Mr. Hopper is both the former director and chairman of the Travis County Bar Association Probate and Estate Planning section and is listed in the Best Lawyers in America. Today, Mr. Hopper is presenting a legislative update. Please welcome to the stage Mr. Craig Hopper.
Thank you. I enjoy being here. I think the EPJ is amazing. I think what the students and Professor Beyer do is unique to Texas, and I think we're lucky to have it. And this is this is the best run CLE I usually attend all year round. Can everybody hear me okay? I'm working off of the remote mic. So what I'm going to talk about today is what is beginning in the legislative session. We are still kind of in the infancy of it, at least, because things move fast. And the legislative session we haven't even met the deadline for filing bills yet. That's not going to be until next Friday. So things will change between even now and next Friday, and things are definitely going to change between now and the end of May when the session is out. So what I'm going to be talking about today are some of the bills that have already been filed. This is kind of a sneak preview. This is also one of the most difficult speeches I have to give because things move so fast, and a lot of the things we'll be talking about today you may not ever hear about again. So after the session, the paper's a lot more cohesive because we know what has actually passed. And so right now I'm just going to try to point out some of the highlights of what we've seen so far and kind of what to expect. I'm also going to be focusing on the REPTL legislative package. That's the Real Estate, Probate, and Trust Law section. I'm actually the chair of the Estate and Trust Legislative Affairs Committee. So I'm the chair of SBOT's REPTL ETLAC. So and what we'll be doing, what we've done every session is we have several bills that go through a long process in order to get approved by the State Bar. We actually have a couple of other speakers on today's presentation that have been very involved with the legislative package, including Laura Davis and Laura Upchurch. And our thanks to them. Oh, and also Professor Beyer, who's also the chair of the Digital Assets Committee. So they've all been working hard to get bills ready to be filed, and we'll continue to present those at hearings over the next couple of months. So we've done a lot of things, and other people have also done a lot of things, and we're going to talk about some of those and what's going to be happening over the next several months. A lot of people need to be thanked, including everybody who's a chair of the substantive sections of REPTL, but also Bill Pargaman, who's the past chair of all of REPTL and was a former chair of the Legislative Affairs, And he is the guy who wrote this paper. And so he's done this several sessions now, and I owe him a lot of gratitude because if he writes it, that means I don't write it. So first, let's talk about, there's a lot of preparatory materials in there. I'm going to try to pass over those so we can get straight into the meat. I will run out of time. I won't be able to cover everything. There's a lot of information in here, so look at it at your own leisure. But keep in mind that these things are going to change. And so if you ever want to see what the most current update is, you can go to Bill Pargaman's website, his firm's website, and he usually updates, he's very good about updating the paper, so you can see kind of where bills are, and especially at the end of the session. And all that information's inside the paper. So going to page 6, we're going to talk about what the Reptil legislative package started off as. So we normally have 4 main sections that we try to do improvements to various areas of the various codes. There's a Decedents Estates Committee, the Guardianship Committee, the Advanced Directives Committee, and the Trust Committee. And this year we also have a Digital Assets Committee. So we have kind of 5 sections this year. Originally that was going to be 5 bills. When it goes through the process, things can get divided up if the Legislative Council determines it's more than kind of one topic. So we actually have 9 Reptil bills that have been filed. So 9 in the House and 9 in the Senate. So that means we're tracking 18 bills of our own, in addition to all the other bills that we're doing. The first bill that I want to talk about is the Reptil Decedents Estates Bill. And it's a long bill. It does a whole lot of tinkering to the Estates Code, trying to take care of little minor problems that have occurred. This year we're not doing too much substantive in it, but I want to point out some of the highlights. One is that in subparen C, you'll see it says adoption by estoppel. There's been some confusion in the past as to whether or not, or the rules about what an equitable adoption is for the purposes of determining rights of heirship. And so now we're clarifying that anybody who is considered equitably adopted has the same rights as somebody who has been legally adopted as a child. So that's good. That's hopefully going to be helpful to practitioners. Another thing on E is that we are proposing that the small estate affidavit amount be increased. It's been $50,000 for several decades now, and so we are asking for it to be increased to $75,000 so that will hopefully allow greater access to the probate process for folks who have small estates and don't want to have to pay for attorney's fees to go through formal probate. So when that's available to them, that should be useful. Page 7, G, we're going to try to change, or we're trying to give a time limit to modify or reform a will. If you recall, last session, we have added something to the Estates Code that allows practitioners to go in and ask for the court to modify or reform a will for several reasons. One reason is that in case it helps to have people qualify for governmental benefits, but another big reason that affects all of us is that it allows a way to fix Scrivener's errors that was not otherwise available before this unless there was an ambiguity in the will. So, but when we included that last session, we didn't say how long you had to go in and reform a will. So obviously if a will has been probated, it doesn't make sense, or it can be confusing to have somebody try to reform it several decades away from the original probate. So now we've got a time limit on there. It's going to be 4 years. So 4-year statute of limitations to go in and modify a will after it's been admitted to probate. Another thing that may be helpful is under H, time limit to open up an administration. So as you know, you can't have an administration if it's been 4 years after the decedent's death, because usually the creditor, the statute of limitations for creditors would have already passed. So, but the statute was unclear about what happens if you file an application for probate before the 4-year statute of limitations, but for whatever reason, it doesn't actually get heard by the court until after those 4 years. And so we're providing now in the statute, clarifying that as long as you file something before that statute of limitations period runs, you can get your letters of administration or letters testamentory after 4 years have actually passed, if that's when the court finally gets around to either granting them or dealing with the contest. On K of this section, we're hoping to change the rule about where you have to publish your notice to creditors. This may not be something you've ever had to think about, and a lot of people didn't think about it until somebody raised it and created a problem. So the statute currently says that when you publish your notice to creditors, that it has to be done in a newspaper printed in the county in which the letters are issued. Now, over the years, many smaller newspapers or even bigger newspapers are no longer printed in the county in which the letters may be issued. So, like, for example, this was found because all of the various the various, the business journals throughout the state are all published in Dallas. And so even though maybe the Austin Business Journal, it's not published in Travis County. So in theory, publish a notice to creditors there and it's not effective. So now we're changing the statute to make it say what we always thought it said, which is that it's okay that you can publish a notice to creditors in a newspaper of general circulation in the county. So it doesn't have to actually come off of a printing press in that county. One thing that is maybe the most substantive thing in our bill, it comes down in O, which allows for non-pro rata distributions inside an independent administration. So now, as you may know, that we don't necessarily have that power to make non-pro rata distributions if the will is silent, but now an independent executor with a power of sale in the will can go ahead and make those non-pro rata distributions among beneficiaries, so that way there's more flexibility in dealing with moving assets, but also at the same time avoiding whatever adverse income tax consequences might otherwise occur by a transfer like that. You'll also see in Q that the many times in the estates code where we refer to last will and testament, we're going to say now it's just will. That the rest of that phrase is somewhat archaic, and most people, including myself, couldn't really tell you what the difference is between a will and a testament. Professor Beyer, I think you can. Anybody else, can y'all tell me what the difference is? Look at that. That was my question, so I could take a drink of water. So moving on. Those are the high points of the Reptil bill. Now on page 8, we'll talk about a few more decedents estates bills that have been filed so far. One is 7.3. You'll see where there's a bill that would require that in all probate applications that the last 3 numbers of a driver's license and social security number be listed in the application. That is currently the rule for everything except for statutory probate courts, but it isn't the rule for statutory probate courts. This would make it uniform throughout all the various probate courts that you've got a list that identifying information for the applicant and the decedent. Another bill under 7.4 deals with a way to penalize people who might lie on their affidavit in lieu of inventory. So if you're not going to file an inventory, you can file an affidavit in lieu of inventory, and the part of that affidavit requires you to state that all of the beneficiaries of the will that are supposed to get an inventory have actually got the inventory. You're not filing it for public record, but they've all received it. So there's a concern that maybe people were not taking that seriously and might take a shortcut and not prepare an inventory and instead just get everybody to, or just say that, well, I did it, but since nobody was going to complain, I didn't really want to spend the time or money to create the inventory. Well, now if you get caught doing that, there is going to be a penalty where you can be fined up to $1,000 and also be liable for any damages caused by the misrepresentation. Will that really affect people? I'm not too sure, but it's out there right now. So that's something that we'll have to be looking at. Let's see. So now let's go to the next section about guardianships. We'll talk about what the Reptil guardianship bill does. So the Reptil guardianship bill doesn't do too much, or at least we're hoping it doesn't do too much, but now there's some committee substitutes being floated around, so it might be different when it finally reaches the floor. But here's what it's trying to do, and hopefully these issues are going to be helpful if we can resolve them. First is that it clarifies who has to request for permission to intervene in a guardianship proceeding. Last session we provided that, we amended the statute so that it said that if somebody who wanted to intervene in the guardianship proceeding, they first had to ask the court for permission to do so. There was some confusion about who all had to ask for that permission. For example, if you're already on the certificate, or if you're already guaranteed to have notice of a proceeding, like you're a family member, a close family member, should you also have to ask for permission to intervene if you're already kind of considered part of the application? Well, we didn't think that was the case, but that might have been somewhat confusing, so we we're amending it now to make it clear that if you're already part of the group of people that are required to get notice in a guardianship application, you don't have to ask for additional permission to intervene. That's really just there to make the people that don't have any good reason to be in a guardianship contest to explain to the court why they are there before they can clutter up everything. Under B, we're also we're amending a provision that says that you don't have to say where a ward is if they are protected by a protective order under the family code. We're changing that to say that you also don't have to give their address if the person was previously protected by such an order. So that way, if there's some bad guy out there trying to take advantage of an incapacitated person, or has in the past, that this way we're not going to tell them exactly where that incapacitated person is. C deals with the supported decision maker agreements. Show of hands, how many people out here have done SDMAs since they were provided for in the last legislative session? Okay, SDMAs are something that is kind of like a power of attorney light, where somebody who is incapacitated but still has a high degree of ability to make decisions for themselves can name somebody to kind of be their helper and help not make decisions for them, but get access to information to help them make decisions regarding their finances and regarding their care. And so that was in the statute. It wasn't our bill, but it went through and was passed last year. And so now that vehicle is out there. Well, we were concerned that perhaps that could lead to a slippery slope of people trying to abuse incapacitated folks, where it's not too far from helping somebody to make their own decisions to helping themselves from the incapacitated person's funds. And so we wanted to clarify that there is a fiduciary relationship involved between the incapacitated person and the person who's named as the supporter. And so that's what that provision does. There's been some controversy in that. The disability rights groups may have indicated that perhaps that will have a chilling effect, that somebody who would otherwise be a supporter doesn't want to be a supporter if they have to be considered a fiduciary. A lot of us think that, well, that's really not the case, that usually if somebody wants to support somebody, they don't mind being a fiduciary because they're doing it out of the goodness of their heart, not to do it to steal money. And if they don't agree to it, that raises an alarm bell. That's my opinion. But we're working on that. We're hopefully going to still create some sort of additional protection for the folks that signed these, so that if an agent does go rogue, that it is clear that they're a fiduciary and that they have certain liability associated with that. And so those are the few things that the reputable guardianship bill does. And one thing I'd take a step back here. Keep in mind that even though we refer to these as reputable bills, they're only reputable bills when they start. So they've gone through this long process where ultimately we go to the state bar looks at it, a big committee looks at it, makes sure there's nothing that's going to be too crazy, and then they approve it. And so then we go and try to find legislators to carry these bills. But then once they take that bill, it's their bill. It's not the reputable bill anymore. And so amendments can be made, things can be added onto it, things can be dropped. We generally are consulted about those things since we're the ones that brought it to them. But ultimately, it's the legislator's bill. So even though I refer to something as a reputable bill, at some point we've got to let that baby go and take care of himself. So the reputable guardianship bill, we've talked about that. A couple other things that in the guardianship world that are currently on the table through bills. One is under there at 8.3, discussion of using person-first respectful language. So the situation there is that there's a bill that says we're not supposed to use the phrase ward anymore because that is not as gentle or preferred as other words. And so what is going to happen is that we're going to try to phase out the use of the word ward and instead replace that throughout the statute and in any new bills or any new statutes with the phrase of incapacitated person or a person with a guardian. So the four-letter word is now going to be several words. The one option that was originally discussed and I think has been implemented in other states is to have it be a person under guardianship, which sounds like a great idea until you think about what the acronym of that is. And so the thought was that, well, we don't want people to be called pugs because probably pug might be even more demeaning than the phrase ward. So we're not going to have pugs in Texas. Going to page 9, one thing that there may be some opposition to, this is not a reptile bill, but deals with attorney certification and guardianship proceedings. For those of you who practice in guardianship, you know that if you're going to be an attorney ad litem, you've got to have a 4-hour CLE, and you've got to renew that every so often with additional guardianship-related CLE. Last session, 2 years ago, it became the rule that now if you're going to be represent somebody who was applying for guardianship, so not just the ad litem, then you also had to have that same sort of CLE. Well, now the thought is that, well, what if you're not applying, but you're contesting, you're otherwise objecting? Don't we want those people to have the same sort of basic understanding of guardianship proceedings that everybody else does? And so now there is a bill that would require that any attorney representing any person's interest in a guardianship proceeding have the same sort of CLE requirement to take before they can enter an appearance. Going to 8.6, another bill that's not reptile, deals with the creation of a guardianship, creation of additional standards to monitor and ensure the quality of guardianship programs. If you're part of a guardianship program, then you'll want to look at this bill to see what you think about it. I know that I'm already kind of running out of time, so I want to move on from that. But that is something that is there to hopefully make sure that all the guardianship programs that are out there are doing what they're supposed to be doing and that they are employing proper individuals. 8.7, removal of a guardian, which is now going to allow a court to remove a guardian with less notice than is otherwise currently required by statute. So right now, if there's going to be a guardian removed, they're supposed to get personal service. Now that the amendment is that instead of personal service, that can be done by certified mail at their last known address. And that does somewhat make sense because usually if a guardian has gone off the rails or disappeared, then you can't really personally serve them. But in order to remove them and so that the incapacitated person can have a new guardian, you have to give them some sort of notice. And so this would allow just a certified mailing to where their last known address was, and so the court can appoint somebody. Going down to 8.9, you may recall that last session there was a bill that passed that requires that if courts are going to appoint attorneys ad litem, then they and other appointed individuals, they have to do it by a list that they keep. So that way a court cannot kind of pick favorites and keep on appointing the same ad litem and ignore other ones that would otherwise be up next in a rotation. And so that occurred last session. Now there's been a bill filed that would change that a little bit so that it allows that if a court is going to appoint a guardian ad litem or a guardian or attorney ad litem, that they don't have to go to the very next name on the list, that instead they can appoint a person from the next 5 names on the applicable list. So what that really means is if you're a judge, as long as you have only 4 incompetent people on the list, you'll be fine. So I don't know if that'll pass, but that's an interesting bill. And right now, the court can opt out of that list if it finds a good reason to do so, because there are plenty of good reasons to do so. So this just adds additional flexibility for the court to make sure that somebody's skills are matched up with the necessity. 8.12, I'd point that out to you. This deals with the Office of Court Administration establishing a new program, kind of a guardianship compliance program that will make sure that in some of the non-statutory probate courts that everybody's doing their job properly, that, for example, that annual accountings are being filed and they contain all the proper information. And this is still somewhat in its infancy, but we'll see how that goes as it goes through the legislature, but it may be that we end up with a new sort of agency that is there to watchdog the various non-statutory probate courts to deal with guardianships. There is also in 8.13 a direction to the Supreme Court to establish a new program, a guardianship court pilot program that would help try to bring expertise in guardianship matters to certain courts that don't already have that expertise. And it provides for what they can do and the method in which they're appointed. And since it's a pilot program that really first has to be established by the Supreme Court, if that does get created, it's going to be several years from now before it's actually implemented. So we'll talk about that more after the bill gets filed. So now let's talk about the trust bill still on page 10. So as I said, Reptil has its own trust bill. Our trust bill last session did not pass because there was one provision in it dealing with directed trust that was kind of ended up killing the bill. But we've taken that out because we don't need that anymore since another law was put into place for it. So our trust bill is very similar to what we had 2 years ago. Some of the highlights of it, one is that it is going to clarify the grounds for reformation of a trust. You can already go in and modify a trust under certain situations, but this is supposed to have the same sort of provisions that we have in the decedents in the estates code for reforming a will, so that now you can clearly modify or reform a trust to qualify somebody for governmental benefits, and also to correct a scrivener's error, even if the document is unambiguous. So it's going to be the same sort of language that we already see in the estates code, but now it's going to be applicable to trusts. Our trust bill has a lot of provisions dealing with decanting. Decanting is fairly new for Texas, and so when we established our decanting statute 4 years ago, where we don't really know how it was all going to, where the weak points were going to be in it, and so now we're coming in to clean up some of the issues that we've either thought about because we've had time to think about it, or issues that were brought up by people trying to use decanting statutes and seeing where the flaws were. And the one thing and to also make it a little more flexible for people to use. One thing that I draw your attention to is under sub-Roman numeral 2 on page 11, which deals with full discretionary trust. So if a trust has full discretion, so that it means that the trustee has a power to distribute principal that is not limited by anything, then now that trustee has greater opportunities to decant into new vehicles that, for the benefit of not only the current beneficiaries, but also for successor or remainder beneficiaries, cannot create a new trust for right now. So it gives more flexibility in the sense that if the trustee was going to have the flexibility to do anything it wanted to do, then now it should be able to also change things around to benefit the further remainder beneficiaries that the settlor might have included. So take a look at all the other things that it does dealing with the decanting, and let's go on to page 12. A few more things that are in our decedent's estates bill that deal with trust code. One is that we're clarifying that if there's a divorce of somebody who is not the settlor of a trust, then but that person is named as a beneficiary, then that divorce does not automatically revoke the status of the spouse of whoever was divorced or the family members, because right now, over the years, we've tried to make it real clear that if somebody has a testamentary provision and they're and they include their spouse and they end up divorcing them, then probably after the divorce, they don't want to benefit that spouse. And so we've clarified that if there are any such bequests or distributions, that they are canceled by virtue of divorce and the person's deemed to have predeceased them. So, but it wasn't clear that what happens if somebody gets divorced but they're not the spouse of the settlor. Well, those persons aren't supposed to have been penalized, and so that's what we're fixing there. Now let's go down to the Reptil Financial Power of Attorney bill. This is probably the biggest bill that we're going to be fighting for this session. As you all, I'm sure, know who do estate planning, that one of our most common ancillary documents is the power of attorneys, powers of attorneys both for medical and for finances. And so we'll always do that for people to tell them that, well, you can have somebody there to make decisions on your behalf if you're unable to. And in a perfect world, you won't ever have to have any sort of guardianship or other court action because you've got this person you trust that is there and can make financial decisions on your behalf. So that's why we have people sign these durable powers of attorney. The problem is that there is no way to enforce them right now. Unlike in other states where there are ways to enforce them, in Texas, a third party, such as a bank or any other financial institution, can just flat out say no because they don't want to have any risk associated with the document. So they can just arbitrarily refuse to accept them. And what that can lead to problems. Among other things, it can mean that if you try to go in and take control of assets for your parent, so they don't have to have a guardianship, just like they had signed, which is why they signed those documents, Well, if the bank says, no, it's our policy to not accept powers of attorney, or it's our policy to only accept the power of attorney that we have generated in-house and that we approve. But now the person's incapacitated, so they can't sign anything. So what that does is that can certainly change somebody's estate plan and create a whole lot of additional costs and the need for a guardianship. And there can also be material money loss involved too. Like say, for example, if you've got to make the minimum required distributions and somebody's incapacitated and you try to make that done within your calendar time frame that you have to do it, and the institution says, no, we're not going to honor this, well, you might end up having liability, financial liability for not being able to make your required distribution, lose some money that way. Also, it may be that if a bank account needs to be frozen because there's some bad actor, maybe a caregiver coming in to try to loot a bank account, if somebody who's a daughter named on a power of attorney tries to tell the bank to do that, the bank might say, well, we're not too sure who's in the right, and so just to be safe, we're not going to honor your power of attorney and you need to go to court and figure something else out. So there's lots of ways that that can cause problems. And so what we're trying to do is trying to have a balance between the use of the power of attorney for our clients and also enough reasonable protections for a third party who's being asked to look at them. And so the next several pages of this paper deal with that because it's a pretty large bill. If you really want to know more about it, you can ask Presenter Laura Davis, who is here and who is the chair of the Advanced Directives Committee and has been doing an amazing job going to the legislature and trying to reach a compromise with banks and other financial institution stakeholders. So, and we're still working on it. We're working hard on this. We've tried to do this several sessions now, and now we think we've got a really good bill, and so we're hoping that it can keep on moving forward. So what does it do? So let's, I'm going to talk about some of the high points on page 13. One thing it does is that it says that if you've got a person has executed a power of attorney outside of Texas and it still fits everything that would make it a valid power of attorney in Texas, then it can still be used by a third party. Or if it has been written in accordance with the laws of that other state, then it should still be a valid power of attorney here in Texas. Just because somebody has moved doesn't mean they should lose the availability of their power of attorney. It also clarifies that when a person is only accepting appointment as an agent when they exercise authority or perform duties as an agent. So just because somebody's named as a power of attorney doesn't create any fiduciary duty for them just by being named. Instead, they've got to actually act on it. And one very new thing it does is it provides that the agent can have a new set of powers, what we're calling hot powers. It's on the 10.4. So even though this is not in the statutory form, we're clarifying that an agent can do certain things where there were questions about whether or not they could do them before, including creating, amending, or revoking a trust, making a gift, and I know a lot of us already include those in our powers of attorney, creating or changing survivorship rights, creating or changing beneficiary designations, or delegating certain authorities under the power of attorney. So it states that, and it clarifies that some of these more generous powers that we may give people, that they actually are going to be valid and that they, even if there may not be any case law regarding them. So that's one good thing that we want to see happen. Now let's talk about how do we get the third parties to accept these powers of attorney. And now I'm on page 14 on 10.10. So what our bill does is it says that unless there's a good reason to refuse it, doesn't even have to be that great of a reason, just a good reason, we'll talk about that. As long as there's no good reason to refuse the power of attorney, then the banks should accept the power of attorney. Now, if a financial institution is presented with the power of attorney, they've got some time to think about it. What our bill provides that if they are presented with one, they can either accept it right away, or they can request a certification from the agent or an attorney's opinion about the validity of the power of attorney, and they can request that to be presented within 7 days. And then they have an additional 5 days in which to accept the power of attorney after this explanation or certification has been presented to them. So it gives them some time to think about it, and that's only if they're going to end up accepting it. they have 12 days. Now, the financial institutions want a greater period of time. I think that they're currently requesting about 20 days, 20 business days. So that would mean that somebody's presented with a power of attorney and they have an entire month before they have to decide whether or not to accept it. And a lot of times we want our powers of attorneys to be considered a lot sooner than a month. So that's one of the sticking points about the bill right now. Most other states have very shorter time periods because they assume that a financial institution can do whatever due diligence it needs to do in a more timely fashion. So the biggest concern for the financial institution is, well, what if we don't want to accept it? What do we do if we know that it's a bad idea? Well, there's plenty of grounds for refusing acceptance, and those are all listed in subparagraph F on page 15. And so it's things like they don't have to accept it if they wouldn't have accepted it if they wouldn't do it if the principal had asked on their own. They don't have to accept it if the agent is asking for something that is outside the scope of what they would normally do. They don't have to act on it if they have a good faith belief that the principal or the agent has a prior criminal financial history, if they know that it's been terminated, if the person cannot give the certification or opinion of counsel that's been requested, all sorts of reasons. And if they are going to refuse that, they just have to give the agent notice that they are going to not accept it. And they have to some degree, give a specific reason, but also they can say that, well, we're not going to accept it because of one of the reasons that are listed in paragraphs 2 and 3, which is a big long laundry list. That's kind of like if we just think that you're violating if you're breaching your fiduciary duty, we don't have to accuse you of breaching your fiduciary duty, but we can say we're not going to accept it because of one of the designations in these subparagraphs, which includes breaching a fiduciary duty. So if somebody shows up and the bank knows that they're bad news, that what they're doing is not something the principal would have wanted, there are ways to refuse it and not have any sort of trouble. Now, if somebody refuses it and they cannot give a reason under the statute, then what will happen is that it provides for a cause of action for the principal or the agent to make them accept it. And if they have to be forced to accept it, then the financial institution has to pay the attorney's fees and costs associated with that. And similarly, if there's an enforcement action and the court finds that that it was rightfully refused, then the principal, or it's actually the principal or the agent is one thing we're looking at right now, is going to be liable for the third party's costs and attorney's fees. So, it's a situation, we're trying to balance everybody's rights. We're wanting to balance the rights of individuals to be able to use their power of attorney properly versus the rights of a bank to not have to expose themselves to greater liability than they otherwise would need to. So it's a lot of information in there, and I'm still trying to figure out the best way to summarize it all, so y'all get to be guinea pigs. I know that went on for a little while. But take a look at that. It's a real important bill, and we're going to keep on pushing on it. Now let's talk about, we're going down to page 17, and other bills related to disability documents. Our reptile bill clarifies that if there's a power of attorney out there and there's a guardianship proceeding, then if it's a temporary guardianship, unless the court says otherwise, the powers of attorney are suspended while the guardianship contest is going on. And if there is a permanent guardianship created, then those documents are going to be automatically revoked unless the court determines differently for some reason. Also, going to 11.2 and several bills that we're dealing with signatures. So a lot of the advanced directives that we have currently are not uniform as to what is required to sign off on them. So some may say I need 2 witnesses. What we're trying to do is include in all those that you've got an option. And you can either have 2 witnesses sign off on an advanced directive, or you can have it done in front of a notary so that you've got a choice, because that way all the documents are similar, and so that you can have just a notary to do all these advanced directives if you don't already have 2 witnesses lined up. And so we're trying to amend several of our advanced directives to make them all uniform. That includes the declaration of guardian. So if you're saying who you want to appoint to be guardian, it also includes the anatomical gift and disposition of remains directives that we have, and the mental health treatment bill. Also point out on our medical power of attorney, we've got legislation that we're proposing that will allow the current medical power of attorney statute to have an optional form, so that, well, it's not a mandatory form. So that way, the many folks out there that are doing things like using 5 wishes or other third-party documents that deal with in greater scope about what the medical powers of attorney should do, that they can use those without fear that they show up at a hospital and the hospital is going to say, no, we're not going to accept that because that's not the Texas form. So right now it's unclear as to whether or not these other non-statutory Texas forms have any validity, and we want to make it clear that you can actually use them, because a lot of people are using them anyway. Going on to, because I'm running out of time, I'm going to go to page 19. I want to point out that one thing we may end up seeing on 12.4 is that, like we have new transfer on death deeds, there may be a transfer on death title now for all motor vehicles that will have sort of the similar rules to a transfer on death deed, so that it can create a more of a joint tenancy or right of survivorship sort of situation that is more enforceable, or at least clearer than what is currently available. I have to talk about the bill that Professor Beyer has worked on, which is the Digital Assets Bill, and now let's go down to page 21. So what has happened is that there's been concern that as there's been so much information going out digitally and assets that people may own, that there's no way to access them if the principal who created them is now incapacitated or deceased. And so, for example, what happens to my Facebook account if I die and somebody wants to access it for whatever reason? Can my executor access it? Well, we didn't know before. Now we're going to make sure that we do know. And so originally there was the Uniform Fiduciary Access to Digital Assets Act that was proposed, but the big guys like Google and Facebook and Yahoo did not like it. So that was then changed to the revised Uniform Fiduciary Access to Digital Assets Act, which, as we are calling it, is RUFADA. So what RUFADA has, and RUFADA has been accepted by the majority of U.S. states at this point. How many by now, Professor Beyer, do you recall? Oh, so not a majority, but close. Any day now. And so what this does is it basically allows access to all these formats, but it also preserves what the principal may have wanted to have done with his information, so that if there is a way that I sign off on Facebook and say that I don't want anybody to ever access my information, nobody can trump that. So my executor can't come in and look into my things if I've already said that for sure I don't want anybody to look at it. But if I am silent, then the executor can have access to it, a guardian can have access to it, so any sort of power of attorney can hopefully have access to it. So it increases the ability for a representative of the principal, deceased or living, to be able to go in and access information, as long as that person had not prevented it before by contract. So it doesn't mean that all of a sudden you get to take in everybody's assets or everybody's Amazon online accounts, things like that. But what it does is it allows access to information that is consistent with what somebody might be saying in their testamentary documents or in their whenever there's a personal representative appointed. One thing I've got about 30 seconds left here. So one thing I want to point out real quick, this is a bill that's getting a lot of interest right now on page 20, dealing with payment of costs associated with an assigned statutory probate judge. That's very important to those of us who work in contested matters, because whenever you're in a county that only has a constitutional county court, if you want to have somebody who knows the probate law, then if there's a contest, you can request that judge ask the statutory presiding judge, the presiding judge of the statutory probate courts, to appoint a statutory probate judge to hear the matter. Otherwise, it goes to a district court. And so a lot of times we will use that. Now there's a bill that says that if somebody's going to do that and request a statutory probate court, then the person who requests it has to pay for that statutory probate court, because otherwise the county has to pay for it. County doesn't have to pay for the district court. They're already getting paid. And so what this can do is it has a chilling effect perhaps on having the proper judge to hear cases that are highly specialized. And so there needs to be some sort of balancing act there that will not bankrupt the county, but also at the same time allows for practitioners to continue to make sure they've got some expertise in hearing cases. So that's one that we're all following right now too. So there's been a lot of activity, a lot of things already filed. It's going to be a lot more filed just in the next week, and then all of those filings are going to be changed and amended. And then by this time next year, we'll know exactly what the legislator has done to us. So hopefully this has been somewhat informative. If not, at least it's been interesting, and I appreciate the opportunity of being here and telling you where we are during the legislative process this year. Thank you.
Thank you, Mr. Hopper. Our second speaker today is Professor Nancy McLaughlin. Professor McLaughlin is the Robert W. Swenson Professor of Law at the University of Utah College of Law, where she teaches a number of courses in the area of estate planning, including a course on conservation easements. Professor McLaughlin graduated from the University of Massachusetts Amherst and received her JD degree from the University of Virginia School of Law. Professor McLaughlin is a member of the American Law Institute and serves as an advisor to the Restatement of the Law Charitable Nonprofit Organization Project. She is a fellow of the American College of Trust and Estate Council, on which she also serves as the co-chair of the Legal Education Committee. Professor McLaughlin is also a member of the ABA's Real Property Trust and Estate Law section, where she serves in many different areas. Today, Professor McLaughlin will be presenting Trying Times, Important Lessons to be Learned from Federal Tax Cases Involving Conservation Easement Donations. Ladies and gentlemen, please help me welcome Professor Nancy McLaughlin.
Thank you. Can everybody hear me? Is my mic working? Okay, great. So thank you all for coming, and thank you for that kind introduction, Amanda. I also want to thank the Law Journal for inviting me back this year, and in particular, Professor Beyer and the student editors. They, as always, have been extremely gracious hosts. So, as Amanda indicated, I'm going to talk to you today about conservation easements, and I have split the talk this morning into two parts. First, I'm going to give you just a primer on the very generous federal income, gift, and estate tax benefits that are available to landowners who donate conservation easements. I just want to make sure we're all on the same page before I get to the second part of the presentation, where I'm going to walk you through some of the more interesting developments in the law since last year's conference. I have provided you with what I hope is a very comprehensive outline. It's a fairly long outline, but it explains in great detail how to file a tax return when you have a client who is claiming a federal charitable income tax deduction for the donation of a conservation easement. I am not going to walk you through that outline this morning. I have provided it to you as a resource, and all of the voluminous case law that has come down in this area is discussed in that outline for you, and it does also include a number of appendices that I think that you will find really helpful if you are working on a conservation easement donation transaction. I've tried to save a few minutes at the end for questions. You also have my contact information. It is on the outline and it's here on the slide. You should feel free to contact me if you have questions on easements. I'm happy to answer them. And I'll also share the PowerPoint slide with you. I'm sure you can receive that if you ask the students who are running the conference. Now, before I turn to the tax incentives, I just want to give you a very quick description of a conservation easement because some of you may not be familiar with this concept. So what is a conservation easement? It is a deed that is conveyed to a government entity or charitable organization, generally a charitable conservation organization, and they're often referred to as land trusts. The deed restricts the development and use of the encumbered land in perpetuity, or generally in perpetuity. You can have term easements. And the deed does this for the purpose of protecting conservation attributes of the land, such as open space or wildlife habitat. All states, including Texas, have what is known as a conservation easement enabling statute. And what these statutes do is they remove the common law impediments to the validity and enforcement of conservation easements, which are generally held by government entities and land trusts in gross, meaning they are not held in connection with an appurtenant or benefited parcel of land. And at common law, as many of you may remember from your property law class, in-gross land use restrictions were disfavored because they were considered as constraining economic development. Over time, however, we have grown to understand that restrictions on land use that protect important conservation values, like open space or watersheds or wildlife habitat, we understand now that those kinds of restrictions provide important benefits to the public, so state legislatures across the country were willing to remove the common law impediments to in-gross land use restrictions in this very special context. Texas enabling statute is based on the Uniform Conservation Easement Act, and this is a cite to an article that was written by one of the principal drafters of that act that walks you through the act, and it's very helpful. Now, as you can see from this slide, there has been a dramatic growth in the use of conservation easements as a land protection tool over the last several decades. National Conservation Easement Database has gathered data on easements encumbering almost 25 million acres throughout the United States, but it estimates that there are actually roughly 40 million acres now encumbered by easements. That's an enormous area, right? Just to give you a sense of it, it's almost 50,000 central parks. It's more than the total land area of New York, Connecticut, and Vermont combined, and it's approximately 18 times the size of Yellowstone National Park. And if any of you have ever visited Yellowstone National Park and driven around, you know how long it takes to get anywhere in Yellowstone. So we're talking a lot of land. Much of this growth has been driven by the very generous federal tax benefits that are provided to landowners who donate easements as charitable gifts. There are a total of 4 federal tax incentives provided to landowners who donate conservation easements. The incentives, however, vary depending on whether the easement is donated during the landowner's lifetime or after the landowner's death. If an easement is donated during the landowner's lifetime and the donation satisfies all applicable requirements, the landowner is going to be entitled to 3 federal tax incentives. The first is a federal charitable income tax deduction under Section 170H of the Internal Revenue Code, and the deduction is generally equal to the value of the conservation easement. How do we value an easement? We look at the difference between the fair market value of the land before the easement is placed on the property restricting its development, and the fair market value of the land after the restrictions on development have been placed on that land, and the difference between those two values is the value of our easement and the value of our deduction. Our second benefit is a charitable gift tax deduction, also generally equal to the value of the easement. When you donate an easement, it satisfies all the requirements. The transfer is not subject to gift tax, and then when the landowner dies, it's the land subject to the restrictions that is included in the landowner's gross estate for estate tax purposes. We also have an additional estate tax exclusion, When a landowner dies, the landowner's estate can elect to exclude up to an additional 40% of the value of the land subject to the easement from the landowner's gross estate. There is a cap on that of $500,000, but if a couple plans properly, it can double to $1 million. So those are our lifetime donation benefits. If we're dealing with a post-mortem donation, and again, if you satisfy all necessary requirements that we'll talk about, the landowner's estate is going to be eligible for 2 federal tax incentives, a charitable estate tax deduction and that estate tax exclusion that I mentioned. Now, despite the ability to make a post-mortem conservation easement donation, it's generally not advisable for a landowner to wait and hope that the donation is made after death. Obviously, a landowner, if he does that, is going to forego the very generous charitable income tax deduction. And also, there's really no guarantee that the post-mortem donation is going to be made. If the donation isn't mandated in the landowner's estate planning documents, and if you're going to go ahead and do that, you might as well donate the easement during lifetime and have more control over it. But if the donation's not mandated in the estate planning documents, then your personal representative or trustee is generally not going to have the authority to make the donation. And there's also no guarantee that a landowner's heirs, descendants, are going to make the donation after the landowner dies. As many of you know, there are often significant disagreements among heirs after someone dies regarding the disposition of the property. So if you have a landowner who really cares about their property, wants to see it protected, best not to wait until after the landowner's death. So in December of 2015, Congress made certain enhancements to the Section 170H charitable income tax deduction a permanent part of the code. And this means that individual easement donors are permitted to claim the resulting deduction from an easement donation to the extent of 50% of their adjusted gross income each year in the year of the donation and the following 15 years, so over a 16-year period. And farmers and ranchers, including C corporations, if they make qualifying donations, they can claim the deduction to the extent of 100% of their AGI over that 16-year period. So farmers and ranchers that make qualifying easement donations could potentially avoid paying any income tax for 16 years. That's an incredibly generous incentive. There is no other charitable donation that is treated as favorably for federal purposes. Now, it's not all happy news in this context, though, because the deduction has been subject to a fair amount of abuse, most commonly valuation abuse and failure to satisfy the requirements under 170H. And the IRS has been auditing and litigating abusive easement donation transactions over the last several decades. And when you do look at the outline, you'll see in Appendix C, I've listed all of the cases in this area. Since 2005, the courts have issued more than 85 opinions involving challenges to claimed conservation easement donation deductions. That's more case law than in any other charitable context, and there were just 12 new cases issued last year. I don't mean to scare you, though, right? There has been a lot of abuse and a lot of IRS oversight and litigation, but it is possible to donate a good easement and satisfy all the requirements, and that's exactly why I have provided you with that comprehensive outline, because it will tell you how to do that. Now, before I turn to the requirements, I do want to explain, because the requirements are fairly detailed, I want to explain that our Section 170H deduction for an easement donation is an exception to the general rule in our Internal Revenue Code that denies deductions for partial interests in property. Because of the potential abuse in this context, right, we have landowners who are donating easements, but they retain ownership of the encumbered property, and the public generally doesn't have access to the property. So to prevent abuses, Section 170H contains a number of requirements intended to ensure that the deduction is going to be granted only for easements that will actually protect properties over time that have important conservation values and that such protections are going to be durable, right? If the public is going to invest in these easements through the deductions significantly, we want to make sure the public receives the promised benefits over time. So what are all these various requirements that I've been talking about? Well, Section 170H is the main provision. To be eligible for the other incentives, you have to satisfy the requirements for or under 170H, so I'm going to go over those for you. To be eligible for a deduction under 170H, your easement must be granted in perpetuity to a government entity or charitable organization. You can't give it to your neighbor, right? It's got to be exclusively for one or more of the 4 conservation purposes set forth in the code, and the conservation purpose must be protected in perpetuity. And the 4 conservation purposes for which easements can be granted are protection of open space, protection of wildlife habitat, historic preservation, and outdoor recreation or education of the general public. Now, the Treasury regulations interpreting 170H contain numerous additional requirements. Donees of tax-deductible easements have to have a commitment to protect the conservation purposes of the donation and the resources to enforce the restrictions in the easement. The easements have to be legally enforceable. This means they generally have to be recorded in the local jurisdiction where the land is located in the year in which the deduction is first claimed. The easements have to prevent uses that are inconsistent with the conservation purposes of the donation, and the easements must also prevent uses that would injure or destroy any other significant conservation interests. Now, any mortgages that are on the subject property at the time of the donation have to be subordinated to the easement. Surface and other destructive mining methods must be prohibited. Baseline documentation establishing the condition of the property at the time of the donation has to be provided to the donee organization so the donee can properly enforce the easement, so the donee can show what the land looked like at the time of the donation. The donee must also have certain notice rights, namely the right to be notified by the landowner before the landowner exercises any potentially destructive reserve rights with respect to the property. The donee also has to have reasonable access to the property. Why? So it can ensure that our landowner is complying with the terms of the easement. The donee must also have enforcement rights. This basically means has to have the right to enforce the easement through legal proceedings. So not done yet. Our donees must also be prohibited from transferring these easements except to other eligible donees who agree to continue to enforce the easements. However, the Treasury did recognize that sometimes change conditions might make the continued use of certain properties that are protected by conservation easements for conservation purposes impossible or impractical. So the regs tell us that tax-deductible easements can be extinguished, but only in a judicial proceeding and upon a finding that continuing to protect that property for conservation purposes has become impossible or impractical. And when that happens, the holder has to be entitled to a minimum proportionate share of proceeds, we'll talk about this later, to be used for similar conservation purposes. So when the easement is extinguished, we give proceeds to the holder, and the holder replaces the lost conservation values. Now, some of you might recognize these last 2 bullet points, hopefully from your Trust and Estates classes, as a regulatory version of the state law doctrine of cypre that applies to perpetual charitable gifts, which of course tax-deductible easements have to be, or they would not be deductible. All right, so now that we have a basic understanding of all the various requirements, I want to turn to our current developments. And I've selected 5 of what I think are the most interesting developments out of the numerous developments that have come down the pike since I was here last year. And the first up is the contemporaneous written acknowledgement requirement. As many of you probably know, a deduction is allowed for a charitable contribution of $250 or more only if the taxpayer substantiates that contribution with a contemporaneous written acknowledgement obtained from the donee of that gift that states whether the donee provided any goods and services in exchange for that donation, and if so, provides a good faith estimate of the value of those goods and services. And an acknowledgement is considered to be contemporaneous only if our taxpayer receives it on or before the earlier of the date the taxpayer filed the return, first claiming the deduction, or the due date, including extensions for the filing of the return in the year for which the contribution was made. Now, there are a number of cases where easement donors failed to obtain this acknowledgement from the donee organizations, and the courts held that neither the easement nor any related documents could serve as the acknowledgement, and the deductions were completely disallowed in those cases. There have been some other cases, however, where the courts have held that the easement or some other related documents could serve as the acknowledgement, and the deductions were not disallowed. Well, in 2016, we had 2 new conservation easement cases in which deductions were completely disallowed because our taxpayers failed to obtain the contemporaneous written acknowledgement from the donee. And the first one is the French case. It involved the donation of an easement to the Montana Land Reliance on property obviously located in Montana. Taxpayers in French did receive an acknowledgement letter from the Montana Land Reliance, but they didn't receive it in a timely fashion. It was not contemporaneous. And while the taxpayers in French argued that their easement deed could do double duty as a contemporaneous written acknowledgement, after a very close read of that deed, the tax court disagreed. And the court said, in order for an easement to serve as a contemporaneous written acknowledgement, it's got to either state that the donee provided no goods and services, or the donee did and it provides an estimate of their value, or it has to provide that preservation of the property was the only consideration provided by our donee organization, and that can generally be satisfied only if the deed says that it represents the entire agreement between the parties. And some conservation easement deeds say that, some don't, and the one in French did not. So the deduction was denied. Obviously a very unhappy situation for both the donor and the donee to have a deduction for a perfectly acceptable easement completely denied because the donee failed to provide that contemporaneous written acknowledgement. It's a very easy requirement to satisfy. If you are representing an easement donor, you need to make darn sure that the donee provides that acknowledgement in a timely manner. So we had one more case in which a deduction in 2016 completely disallowed for failure to obtain a contemporaneous written acknowledgement. And this is our 15 West 17th Street LLC case. This involved the donation of a facade easement on the historic Van Tassel and Kearney auction building. It's located in Manhattan, and it was built in 1903 as a staging place for horse auctions. So our LLC purchased this building in 2005 for $10 million. 2.5 years later, it donated a facade easement protecting the historic attributes of the facade of the building, and it claimed a $64.49 million deduction for that donation. In other words, it was claiming that this building had appreciated by almost 600% in 2.5 years. Naturally, they got audited, right? Tax court was able to totally avoid the time-consuming and very fact-driven valuation analysis by simply denying the deduction in full because the LLC didn't obtain a contemporaneous written acknowledgement from the donee. The donee in this case is the Trust for Architectural Easements, also or formerly known as National Architectural Trust. And this trust has been the donee in most of the many cases out there in which deductions for facade easements have been denied for a variety of reasons. Now, a very interesting aspect of this case, in addition to the ridiculous size of the deduction that the taxpayers claimed, is that the Internal Revenue Code provision that governs our contemporaneous written acknowledgement provides that failure to obtain an acknowledgement from the donee can be excused if the donee organization files a return containing the necessary information, and here I quote from the regs, on such form and in accordance with such regulations as the Treasury shall prescribe. So when the LLC was audited here with regard to this donation, the Trust for Architectural Easements, the donee, filed its Form 990, its annual nonprofit organization form, with the IRS, and it reported the donation on that form, and it included a statement that no goods and services were provided. Well, a majority of the tax court said that does not satisfy the requirements for the exception from the contemporaneous written acknowledgement requirement, because that exception, said the court, to be effective requires that the Treasury issue regulations and a form on which to report such things in the future, and the Treasury hasn't done so. In other words, you can't use the existing Form 990. And moreover, the court pointed out that the Trust Form 990 on which it reported this donation, it was filed with the IRS 6 years after the LLC had made this donation, and thus it failed completely to carry out the purposes behind enacting our contemporaneous written acknowledgement requirement. Congress wanted, by enacting this requirement, to assist taxpayers in determining how much of their donations are deductible, and also to assist the IRS in assessing tax returns on which charitable donations are claimed. And of course, a return filed 6 years after the donation is made is of no help either to taxpayers or to the IRS. So, court says, doesn't work, your deduction is completely denied. But that was the majority of the tax court. Interestingly, and highly unusual, there were 2 very vigorous dissents in this case. So it is very likely that this case is going to be appealed. However, bottom line for all of us here today is that the best thing to do is to avoid these issues altogether by obtaining, or making sure your clients obtain, a timely contemporaneous written acknowledgement from the donee. As I said, it's a very simple requirement to meet, and I'm sure most of you would rather leave this sort of highly esoteric litigation to some other lawyer and some other donor. Okay, so on to our next requirement that was addressed in 2016, our mortgage subordination requirement. As I noted earlier, if you have an outstanding mortgage on the property that is going to be subject to an easement donation, the lender has to agree to subordinate its rights to the rights of the holder of the easement at the time of the donation. Why is that? Well, if you don't obtain a subordination agreement at the time of the donation, then the conservation purpose of the easement is not going to be protected in perpetuity as is required. Why is that? Well, because if the landowner defaults on the mortgage loan and the lender forecloses, the easement is going to be extinguished because the lender will have a priority right in the land. Well, there are 2 cases that are discussed in your outline from earlier, Mitchell and Minnick, and the taxpayers' deductions for easement donations in those 2 cases were completely disallowed for failure to obtain the subordination agreements at the time of the donations. Interestingly, the taxpayers in those 2 cases argued that their failures should have been forgiven because they said, we have great credit and we would not have defaulted on the mortgage loans on our property. Well, both the 9th and 10th circuits dismissed that argument, and they said, look, mortgage subordination is a bright line requirement, and it would be absolutely absurd to require the IRS to inquire into the creditworthiness of every single easement donor when it's assessing these donations. So those were our older cases. Then in 2016, we had another case in which a deduction totally disallowed for failure to obtain a subordination agreement at the time of the donation. This is RP Golf. It involved a donation of a conservation easement on 2 private golf courses in Kansas City, Missouri. And the LLC in this case claimed a $16.4 million deduction for this donation. And the LLC argued that the two lenders holding outstanding mortgages on the properties had orally agreed at the time of the donation to subordinate their interests, and thus they said, we complied with the mortgage subordination requirement. Tax court disagreed. It found no evidence of binding oral or written agreements with those lenders under state law. Now, the LLC here has appealed this case to the 8th Circuit. I think it's unlikely that it's going to be successful, given that 2 circuits have already opined that the mortgage subordination requirement is a bright line requirement. Moreover, just as the IRS can't inquire into the creditworthiness of every single easement donor, it obviously can't inquire into whether every donor has entered into some binding oral agreement with lenders under various state laws. I also want to point out there were other problems with this easement donation in RP Golf that the tax court noted. It didn't have to rely on them with regard to denying the deduction. But the LLC represented in the conservation easement deed that the golf courses here furthered a specific state conservation policy in Missouri. But then the LLC was forced to concede at trial that the policy actually didn't apply to the properties, which must have been fairly embarrassing for them at trial. Tax court also found that the LLC didn't own a portion of the property that they represented was encumbered by the easement, and that they included in that $16.4 million appraisal of the easement. So substantial problems with this deduction. Bottom line, though, for us today is that you should, if you're helping someone with an easement donation, make sure you obtain a written subordination agreement from any lender holding an outstanding mortgage on that property at the time of the easement's donation. It's generally not difficult to do if there'll be sufficient equity remaining in the property after the easement's donation. Many lenders around the country have grown pretty familiar with conservation easements, given the explosive growth in the use of this instrument that we talked about earlier. Okay, so next up is our conservation purposes test, which was also addressed in a case in 2016. As I noted when we went through the requirements, a tax-deductible easement has to be donated for one of 4 conservation purposes that are set out in the Internal Revenue Code. Last year, I summarized this case, the Atkinson case. Just for the benefit, I'll talk about it quickly for those of you who might not have been here. It involved 2 conservation easements donated on golf courses located in a gated residential community in North Carolina. And actually, this is one of the homes in that community pictured here. Tax court held that the easements did not satisfy either the habitat protection or the open space conservation purposes test, and totally disallowed the $7.8 million deductions that were claimed. The IRS hired an environmental expert in this case. It was the director of Duke University's Wetland Center, and he testified at trial that heavy pesticide use on the courses here rendered them virtually unusable as wildlife habitat. And he also noted that the only birds that were observed on these properties were the Canada geese that you see here, which the owners of the courses attempted to control, and by that I mean eliminate, using a border collie. So no habitat protection purpose here. And the easement also, tax court found, did not satisfy open space, that conservation purposes test, because the public had neither physical nor visual access to these courses that were in a gated and guarded residential community. Well, in 2016, we had another gated residential community golf course case, PBM or PBBM Rose Hill. And this property is located in South Carolina. Court denied the $15 million deduction claimed by the Rose Hill Partnership for the donation of an easement on this course. And the deduction was denied in part because the donation failed to satisfy either the open space or the habitat protection conservation purposes test. Failed to satisfy open space for the same reason, right, as before. The public didn't have access to the course. With respect to habitat protection, The court noted that the IRS, again, hired its own environmental expert, and he testified, according to the tax court, credibly at trial, that most of the bird species on this property are just common backyard species, while the wood stork, which is a threatened species, forages on this property. The storks do not visit this property very frequently, and the property is not good habitat for the storks. Although alligators live on the property, they're a relatively unimportant species ecologically, according to the expert. Most of this property is golf course, dominated by non-native grass species. The course requires continuous application of pesticides and fungicides, resulting in, according to the expert, pollution that was not conducive to wildlife. And the IRS's expert also found, and this is sad for our alligators, that the quality of the ponds on this property was similar to that of waterways in urban areas. Right? So not good habitat protection here, even though it looks quite beautiful. The reason I wanted to point out both Atkinson and Rose Hill cases for you is because they demonstrate that the IRS is now hiring its own environmental experts to assess satisfaction of the conservation purposes test, where there is a question, and this also necessarily involves an assessment of the reserved rights in the easement deed. In this case, reserve rights to use pesticides, but in a lot of cases, reserve rights to build residences and other structures and engage in other uses on the property. Okay, next up is our judicial extinguishment and payment of proceeds to the holder requirement. I noted that the Treasury regulations provide that a tax-deductible easement can be extinguished, but only in a judicial proceeding upon a finding of impossibility and practicality, and with a payment of that minimum, or at least that minimum proportionate share of proceeds to the holder to be used to replace lost conservation values. The first relevant case here is the Carpenter case. I mentioned this last year. It involved easements conveyed with respect to property located in Teller County, Colorado. And instead of saying that the easements were extinguishable in a judicial proceeding, the easements provided that the parties to the easement, the landowner and the land trust, could mutually agree to extinguish the easements. Well, not surprisingly, tax court sustained the IRS's complete disallowance of the deductions in these cases, and it said, to make our position clear, extinguishment by judicial proceedings is mandatory, and the court rejected the taxpayer's argument that the extinguishment regulation contemplates any alternative. And I will note, it did take practitioners in this context a little bit of time to catch on to the fact that to be eligible for a federal deduction, you have to satisfy the federal requirements that relate to the deduction. As a young lawyer practicing in Virginia, I was really astonished to learn that many attorneys who were representing easement donors back then specialized in real estate, what are sometimes referred to as dirt lawyers, right? And they had never read the code or the regulations. Now people have gotten much more sophisticated, and they realize you must satisfy the federal requirements if you want to claim the federal deduction. And this Carpenter holding was confirmed by the IRS in a general information letter, which tells us state law might provide a means for extinguishing an easement for state law purposes, and there are some state enabling statutes that say a conservation easement can be modified or terminated in the same manner as other easements, and that means by mutual agreement, but that's not good enough for federal purposes. If you want your deduction, you've got to satisfy the federal requirements. You've got to put a judicial extinguishment paragraph that mirrors the regulation in your deed. We also have the issue, the related issue of swaps, which are prohibited. And what swaps are, they involve the removal of land from a conservation easement's protection in exchange for the protection of some other lands. Right? Obviously involve extinguishment of the easement with regard to the land that has been removed from the easement. Well, some taxpayers and land trusts tried to argue that swaps don't actually involve extinguishments. Instead, what they argued is All it means is that the easement, which remains perpetual, migrates to different parcels over time across the landscape. Okay? IRS and courts did not buy that argument, and in the Belk case, which involved a conservation easement encumbering this semi-private golf course, again in North Carolina, the Fourth Circuit held that the donation of the easement, which authorized our landowner and land trust to pull land out of the easement in exchange for protecting some other land, swaps, court said not eligible for the deduction. Fourth Circuit said regulations offer a single and exceedingly narrow exception to the requirement that an easement impose a perpetual use restriction. That is our extinguishment, impossibility, and practicality requirement. And it further said, absent these unexpected and extraordinary circumstances, real property placed under easement has to remain there in perpetuity for our donor to be eligible for a deduction. And again, IRS confirms this in a 2012 general information letter telling us, except in the very limited situations of a swap that meets our judicial extinguishment, impossibility, and practicality requirements, contribution of an easement subject to a swap is not going to be deductible. So it is absolutely clear now that a tax-deductible easement can only be extinguishable in a judicial proceeding upon a finding of impossibility and practicality, and with that payment of proceeds to the holder. And the easiest way to satisfy that requirement is to include provisions in your conservation easement deed that state just that. And there are some sample provisions in your outline. Well, in 2016, we had the Carroll case. And Carroll was interesting because it involved the requirement that upon extinguishment, the holder has to be entitled to that minimum proportionate share of proceeds. Now, Carroll involved a conservation easement on a 21-acre residential parcel in beautiful, historic Lutherville, Maryland. Tax court determined that the easement satisfied the open space conservation purposes test. However, taxpayers' deduction was nonetheless disallowed because the formula that he included in the deed regarding the payment of proceeds to the holder upon extinguishment, court said it did not satisfy the regulatory requirement. And the court explained that the proceeds regulation requires that when an easement is extinguished, the holder has to be entitled to this proportionate share of proceeds. It has to be expressed as a percentage, and it's determined by the numerator being the fair market value of the conservation easement at the time of the donation, the denominator being the fair market value of the property as a whole at the time of the donation. So let me give you an example of this. Right? If the fair market value of an easement at the time of the date of the gift, date of the donation is $300,000, the fair market value of the property unencumbered on the date of the gift is $1 million, right? Then the easement represents 30% of the value of the property on the date of the gift, and the holder has to be entitled to at least 30% of the proceeds following an extinguishment when that property is sold or otherwise transferred. In other words, 30% is our holder's minimum proportionate share of proceeds upon extinguishment. Well, in Carroll, the easement deed limited the numerator of this fraction to the deduction allowed for the donation. So if the IRS were to disallow the Carroll donation, and it could be disallowed for a whole host of reasons like failure to get a contemporaneous written acknowledgement, what does that mean? Our numerator would be 0, and our holder would get nothing, no proceeds on extinguishment. Tax court noted that this would provide donors and their heirs and other successors in interest with a windfall upon the extinguishment of the easement because they would get the property back free of the easement and the holder would get nothing. And moreover, the public would be the loser because if the holder gets nothing, the holder has nothing with which to replace lost conservation values when an easement is extinguished. The court also explained that the taxpayer in Carroll could very easily have avoided this problem by strictly following the proceeds formula that's set forth in the regulations. Court also chastised our donor in this case for not engaging an attorney to help him with the donation. Taxpayer here was a medical doctor, Dr. Carroll, and he apparently handled this easement donation by himself, right, without any legal assistance. And I suspect he probably did not read the code or the regulations, and he probably just relied on the model or template easement form that was provided to him by the donee organization. That is a very bad idea. You do not want to do that when you are representing your easement donor. It's very good to start with the template, but you need to make sure that it satisfies all the requirements, right? Interests of donors and donee organizations in these transactions are not completely aligned. The risk of audit, litigation, denial of deduction, interest and penalties, that falls solely on the shoulders of the donors. Moreover, most donees are very careful in their communications with donors to point out that they don't provide legal advice. I also want to note that the result in this case may seem a little harsh. There were some other problems associated with this donation that the court didn't get into because it didn't have to. It just denied the deduction on the non-compliant proceeds ground. But furthermore, I want to note that the result in this case is really no different than the rule that applies to charitable donations generally, like donations of artwork or land or stocks and securities, right? Once a gift is made, it's irrevocable, right? Donors are not entitled to return of their gifts if their deductions should be denied for some reason. And this is an example of that rule that applies elsewhere. Well, the main takeaway from Carol for our purposes today is what I said before. Easement donors should never, ever rely on the donee organization's template easement to satisfy the federal requirements, right? It's the responsibility of the donor and the donor's legal counsel to make sure those requirements are satisfied. Land trusts will sometimes resist making changes to their easement deeds, but as counsel for the donor, you're going to have to insist if you think those changes are necessary to make the easement comply. The other takeaway, of course, is to make sure that your easement deed satisfies the extinguishment, impossibility, and practicality and proceeds components of the regulations. All right, last but not least, I want to mention that the IRS is currently focusing on a specific type of abuse in this context, and that is syndicated conservation easement donation transactions, or what promoters of these transactions call the business of conservation. So what do these transactions look like? Well, you start with a promoter. The promoter purchases undeveloped property, holds it for a year, so the charitable income tax deduction won't be limited to basis. There's a special rule that requires that if it's held for under a year. The promoter then conveys the property into an LLC or some other pass-through entity, and then sells interests in that pass-through entity to multiple investors. The LLC then donates a conservation easement to an agreeable land trust and generates a huge deduction based on a wildly inflated, abusive appraisal. And I refer to the land trust as an agreeable land trust because it is a land trust that agrees to sign the appraisal summary that gets sent to the IRS. Some of you may be familiar with the IRS Form 8283, despite the abusive nature of the appraisal. The huge deduction is then allocated among multiple happy investors, and these deals are generally papered over with very impressive looking promotional materials, development plans, appraisal reports, and even opinion letters from attorneys. But the opinion letters from the attorneys are very careful to opine that all the requirements have been satisfied, but then in fine print they say, but we're attorneys, so we're not opining with regard to the valuation. That's the appraiser's problem. Okay? So in 2016, the IRS issued notice 2017-10, stating that the Treasury and the IRS are aware that promoters are promoting these transactions and identifying certain of these transactions as listed transactions, and participants and material advisors involved in these listed transactions since January 2010, so going back more than 6 years. They have to make disclosures now to the IRS by May 1st of this year, saying, hey, we were involved in these transactions. And I wanted to let you know about this so that you're aware. If a client comes to you and says, hey, I got this promotional material, you can say, wait a minute, let's look at notice 2017-10, see if it's a listed transaction. And of course, if you have any clients that have engaged in these transactions, they need to know that they have to make certain disclosures. And I'll just close by noting that some of the promoters and land trusts involved in these transactions have asked the Secretary of the Treasury to withdraw this notice. Whether that will happen under the current administration is anybody's guess. We'll just see. I had hoped to save time for questions, but apparently not. So I apologize for that. But I will be here for a little while until after lunch, so I'm more than happy to answer any questions, and I thank you all for your attention and patience.
Thank you, Professor McLaughlin. We are now going to take a 10-minute break, so we'll meet back here at around 10:22 or so. Thank you. And please don't forget to sign up for the raffles in the back in the forum. Thank you.